Hey out there, legal warriors, judges don't listen. At least that's what I'm told so many times by people, alleged victims in domestic violence cases who want to drop a no contact order. I can hear that judges don't listen. Is that true? Is that not true? Or are some things that people can do to make sure that it's more likely that the judge hears what is being said? If that interests you at all, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, then please like and please subscribe because more people will get the help they need. So pretty controversial statement. Judges don't listen. That's not what I think. Okay, I think that judges do listen because that's their job, right? And the whole point is to listen. But many times somebody who's trying to get a no contact order that they never even asked for terminated, usually an alleged victim in a domestic violence case, so these are special circumstances, right? They feel that they're not being heard. The judge isn't listening. And so this video is going to cover some tips about how if someone's in that situation, you might be more likely to be able to get a judge to listen, or you can feel like you've been heard and maybe actually accomplish what you want to accomplish, which is getting your wishes listened to if you're wishing to not be separated from your loved one anymore, to get that no contact order dropped. So I think tip one is you need to be heard yourself. If you're the alleged victim in a domestic violence case, don't settle for it. It's not advisable to settle for the victim's advocate to speak in your behalf. If you put yourself in the judge's shoes, you're trying to look at the person making the request. Is this person, he or she, who's making the request to terminate an order, can he or she take care of themselves, right? Can they take care of themselves? Do they seem like they're credible? Do they seem like they're trying to protect the person who's accused of a crime? What vibe do I get off of them? And, they can't get any of that from the victim's advocate. I've sat in felony arraignments on domestic violence cases, and I've heard the advocate blandly read off, I would like to tell the court, supposedly the victim wishes of the victim, I would like to tell the court that I do not wish a no contact order for this reason. It has no effect. I've even seen a judge just sit there and just says, already filling out the no contact order, even though the advocate is most likely told this alleged victim, I'm going to speak for you, don't worry about it, right? And that's just not going to work. I mean, I've seen situations where a prosecutor said, well, the court's not going to listen to you, there's no need for you to be there. Well, in my opinion, that's not appropriate. If you're the person who the court's trying to protect and you don't want the protection, it's totally fair for you to try to get your message through to the court, right? To be at the hearing, to log in. You got to follow procedures, but not everybody in the system is trying to accomplish what you want. Oftentimes the prosecutor and the advocate want the no contact order in place over your objection. So I think tip one, if you're trying to have the court listen to your words, is have them be your words, right? And have you be the one telling them, yourself. What is another second thing I might suggest in these situations? Well, it's sort of a tip that we learn in the customer service business. If you're having someone not paying attention to you, if you're having someone look away from you, look down to you, not listen to you, just keep rambling on, use their name, right? You got to be respectful to the court. I use your honor, and some people use the court. But if someone's not paying attention, learn what the judge's name is. At least their last name. Speaking someone's name, we all have an ego. We pay more attention when someone speaks our name, right? In a respectful manner, right? But if the judge's last name was Smith, Judge Smith, I really appreciate you listening to me today. Judge Smith, don't use their first name, right? That would be inappropriate. But if you use the judge's actual name, they might be more likely to go, oh, well, they know something about me. They know my name. Maybe I'll listen. It's just sort of a natural thing that if we use someone's name, they're more likely to pay attention. Now, if we're in the customer service business, you want to use the first name in that case, right? Harry, I hear you, Harry, because we want to hear our name. It's an ego thing. So that can be useful. Now, third thing to think about in getting someone to pay attention, most communication is nonverbal, but out of the verbal part of communication, tone and inflection mean everything, right? And so, did you notice when I was the victim's advocate, I would like the no contact order dropped? Not very convincing, right? It's like no one's going to listen to that. Now, using a tone that has some monotone up and down and doesn't sound afraid and scared could be useful. Your Honor, thank you so much for hearing me today, and I'm really glad, and I want to tell you why it is that I don't want this no contact order. I might pay more attention to that than Your Honor, I really don't want the no contact order because, well, in one situation I sound really scared and not sure of myself, therefore I need to be protected more. In one, I sound totally vibrant and know what I'm talking about, and maybe that creates an impression that I'm less likely to need protection. So, all of these things matter in deciding what to do. How else can you get the listener to pay attention? Well, say the things they care about, right? And number 4, say the things they care about. Have you done a safety plan? Have you spoken to the victim's advocate and done a safety plan where if something goes wrong, you know what to do? Do you have your own job so I'm not financially dependent on whoever the defendant is, right? Are you afraid, right, for the future, right? No, I'm not afraid for the future, right? Dear court, I really appreciate what you're trying to do for me, but sometimes one might consider that if we're not being heard, that we're being disempowered and re-victimized by a system that wants to tell us it knows what's best for us. Not everybody is the same. So, saying what is more likely to get a positive response from a listener, they're more likely to listen than if it's the same old stuff, right? I love her. I love her so much. I don't want to be away from her. Please drop the order, sir. Is less likely to get someone to pay attention, right, to what we're saying and to listen, because this is about the perception from people trying to terminate no contact orders that the judge isn't listening. The judge is listening, and Jason may not just be very effective what you're saying. I think the final thing that you want to point out if you're in person is the body language. If you happen to be in person and not on Zoom, you want to have body language where you present in a way that doesn't that appears big, right? They're going to pay attention to someone that has the louder voice, that projects, that makes eye contact, right? That maybe smiles, right? That shakes their head. Yes, you can use it's important to use body language to get attention, right? To be respectful, but also to present the image where you're going to be listened to. Because again, this is about whether or not you're being heard, whether or not you're being listened to. So, none of this is legal advice, and none of this is advice that is directly only applicable to a person trying to get a no contact order dropped. It's just, to get people to listen to us, we have to make it so there's something that we're saying in a way that we're saying it, right, that makes us worth listening to, to pay attention to us, because how much competing things we're all in our head, all this stuff, I remember when I was a prosecutor, I had to walk up to a juror once who was falling asleep, because I guess that wasn't very good 30 years ago, and I had to start pounding on the juror box in front of them to get them to pay attention, right? It's like you have to do what is necessary to get the attention of the person that you're trying to get the attention of, but in a way that works, in a way that's respectful, and hopefully a way that communicates your wishes, and you'll be more likely in any walk of life to get what you want. So I hope you found this useful. If so, liking and subscribing, I'm going to ask for what I want, would be a big help. More people will get to the information they need. And if you need help, if you need representation in a criminal case, either as the defendant or even in some cases as the alleged victim, feel free to reach out to us. We've been doing this for more than 20 years. We'll identify a way forward, and we'll listen to what happened, and we will be there for you. Thank you.